would encourage you to find out a lot more about the law firm on the firm's website, which is fwhlegal.com. We're also on Instagram, YouTube, Facebook.
Grindr?
No. God.
This case should never have come to trial.
I don't think it's fair to call my clients frauds. Because one time I turned into a dog and they helped me. Thank you.
Your Honor, we would like to withdraw our plea of not guilty and enter a plea of guilty.
This trial is a travesty. It's a travesty of a mockery, of a sham, of a mockery, of a travesty, of two mockeries, of a sham.
If we are to have faith in justice, we need only to believe in ourselves.
And the truth shall set you free!
How do you plead, guilty or not guilty?
Oh, guilty, but with a real good excuse.
I think the truth will come forth.
You can't handle the truth!
Hello, everybody. We have overcome the technical difficulties to bring you more Law Light. Brought to you by Foreman Watson Holtree, fwhlegal.com. PJ and I are situated in the high-rise white brick edifice. We are seated in the library studio. We have all of our machinery up and running, and it's time for more podcast.
That's right.
How are you?
I'm good.
Good?
Good. I'm tired. I didn't sleep well last night. I don't know why.
Okay.
I went to bed early, too.
Yeah. Well, sometimes when you go to bed a little earlier than normal, your body senses it, and it's just off its little,
I don't think it was a fan last night.
So, didn't like it, huh?
Mm-mm. And then I woke up like in the middle of the night with my cat pushing on my face with his paw.
Oh.
And then my TV did this weird like flash thing.
Poltergeist.
Maybe. The TV was off. And all of a sudden there was this flash of blue in the room, which I can only assume was the TV because there's nothing else in the room that would flash.
A couple of weeks ago I saw on a post, I think it was on Facebook, but somebody asking what movie or as a child like disturbed you the most? Mm-hmm. And mine was hands down Poltergeist.
Really?
Oh yeah, that movie. Yeah, it got me good.
I love that movie.
So
it's a Toby Hooper.
What is it?
Spielberg classic.
Isn't that it? Right.
Yeah. Now the old man in the second one. God loves the little children. Right. That guy. Ugh, he gave me nightmares. I love the second one too.
Yeah, I've seen them both. I don't know why I watched the second one after what the first one did to me. And I actually watched the first one a couple of times as an adult. But it's not as bad.
Now, was it because of the clown? Because I know a lot of people get freaked out by that
just
clown.
The whole TV and the skeletons buried in the yard and all that.
Yeah, I love that movie.
Okay, couple things that I wanted to talk about today. One is that I want to bring a little law talk into the podcast. We haven't done that yet this year. Of course, it's only ours. Yeah, well, actually, we did last week. We talked about impersonating an officer. Yeah, right.
Yeah.
So as you can see today, I've got my
you look very nice
suit and tie on, and I'm headed to court. And I want to talk a little bit about the professional courtesy between lawyers.
Okay.
We've never discussed this topic, I don't think. I mean, directly.
Not that I'm aware of.
Directly. I will kind of come at this. You've had some discussions collaterally when we're on our podcast about like different projects you've worked on, and that there's other guys in this area that do similar type things, and that while you don't really consider them like competitors, there's an obvious, hey, we're all trying to kind of do the same thing, and I want to be better at it, or I want to get more notoriety and that type of thing.
Right.
There's several things about attorneys that I've come to know. I learned it early in law school. Attorneys tend to think highly of themselves. Now, I'm not talking about just pure arrogance. I mean, I just think that you have to have a level of confidence, especially if you're a litigating attorney, okay? Somebody that's in the courtroom, that is in the adversarial setting. If your job is drafting leases and drafting documents and stuff, and you're not going to be in a competitive type, maybe not as much, but to some degree, you have to have confidence in yourself to be able to represent people in adversarial settings, because you have to have confidence in the way that you talk, in the way that you think quick, in the way that you're organized. You have to have confidence in those things, or you won't do your job well. But with that territory, sometimes that can seep over into an arrogance or just a little bit too much of a thinking highly of yourself and that kind of thing.
Right.
The way that then will manifest itself in cases is that there will be this jockeying for one-upping each other or that type of thing. And as much as people would like to think that doesn't exist within the practice of law, it does, and I'm here to tell you it does. I have tried my hardest over my career to be someone that when an attorney finds out that I'm on the other side of the case, that their thought pattern is this. Number one, he's going to be prepared. Number two, he's honest. What he tells you is straight up. He's not going to play games with you. Number three, that, if you treat him well, he'll treat you equally as well or better, okay? That's what I want people to think of me as an attorney. I don't want them to think, oh, he's a pushover because he's nice. I want them to, he's well prepared. He's going to do a great job representing his clients, but he's not a jerk. He's not an ass.
You want to be respected.
Right. I'm going to court today on a thing called a motion for default judgment. And let me give that to you in as simple of words as possible. It's like missing a bill. If you miss a bill, they turn off your lights, right?
Right.
If you don't show up and your turn at the doctor's office, maybe the doctor's office cancels you as a client, as a patient, and says, don't bother coming back, right?
Yeah.
You don't show up. A motion for default judgment is similar in the setting of law, all right? So what happens is that someone will file an initiating complaint, which is basically the document that starts a case, okay? They put that over in the courthouse, in the clerk's office. That document is served upon whoever the case is against, all right? And when I say served, that means given to, all right? Yep. So I file a complaint in the court, and I make sure that a copy of it is hand-delivered to the person that the lawsuit is against. And we have a rule book. It's a you've probably seen it on my desk, that blue book. It's a rule book. And it said that the law in Kentucky is if you get a complaint served against you, you have 20 days to file an answer. In a car wreck case or in an injury case, a lot of times you give it to your insurance company. Your insurance company hires a lawyer, and then the lawyer files an answer. And I can't tell you how many times in my career that the person that gets served the papers takes 2 weeks, even though the summons tells them you have to file an answer in 20 days, you have to file an answer. They will wait, and then they'll get it to their insurance company. And by the time it reaches the attorney, there's like a day or two before the 20-day deadline. And I can't tell you how many times I've gotten a phone call from the attorney going, oh my gosh. And you know what I say to them? Hey, don't worry about it. Take your time, get your answer, and we'll start the ball rolling.
Right.
Matter of professional courtesy. Right? Matter of just treating someone the way you'd want to treat if you were up against the deadline.
Absolutely.
If the answer's not filed, the reason they panic is because if the answer's not filed in time, you can file I can file, because I filed the complaint, a motion for default judgment. Exactly what it says. I'm asking the court because they defaulted. They did not pay their bill. They didn't show up for their appointment. They didn't file their answer. Right. I'm saying, Judge, give my client a judgment because they haven't shown up. And it's a pretty, it's a fairly radical move because it's like, hey, they're not answering. Let's end the case.
Right. That's what you're asking. You're just directly asking the judge. You make the decision and make a settlement for my client.
Not a settlement. Just say, here's what I want. And now you can't put some crazy number in there. And sometimes the judges say, what's that number based on? And you have to be able to give it to them. But you ask for a default judgment. So I have a case. And here is the simple fact pattern. In October, I told the insurance company, look, you're ignoring my demand, a demand that you had worked on, a video demand. I said, you're ignoring it. About had enough. You were supposed to do something in 30 days. I've given you another 30 days. You haven't done it. Again, courtesy. Haven't done anything. So here's what I'm going to do. 1 week from today, and this was written on October the 28th by email to the adjuster. I'm going to file a lawsuit in Davis Circuit Court. Not only am I going to file it, but here it is. And I gave him a copy of it. And I said, it's going to be filed on November the 5th. Okay? So you would think at that point they would contact me and want to discuss settlement.
That would be the wake-up call.
November the 5th comes. I wait until 4 o'clock in the afternoon. At 4 o'clock in the afternoon, I file my complaint, just like I said I would. Okay? And that kind of goes back to what I said. When somebody gets me on the other side, when I say I'm going to do something, that's not just a bark. I will bite, right?
Yeah.
Okay? And so I file the complaint. I get the complaint hand-delivered, served on the defendant on November the 14th. So it takes me 9 days to find this guy. Okay? He lives down about 40 miles from Owensboro. I serve him, and so his time is running starting November the 14th. So 20 days from November the 14th is December the 4th. December the 4th comes, and guess what? No answer.
Nothing. Wow.
No answer. So I wait. The 4th, I believe, was like a Thursday or a Friday, so I wait until the following Monday or Tuesday. I contact the adjuster, the insurance adjuster, and I say, listen, that complaint I sent you, I filed it, and I served it on your guy on November the 14th. The answer was due on the 4th. You're late. This is the 8th. But I tell you what I'll do. I will wait 7 days before filing my motion for default judgment. And I tell the judge, give him a week, get you an attorney, get you an answer, that type of thing. So a week goes by, no answer. I file my motion for default judgment. And because I, again, going to go above and beyond being reasonable, I take that motion for default judgment, attach it to an email, send it to the adjuster and say, on the 8th, I told you I was going to do this. I'm doing it. Here it is. This is a motion for default judgment, and I'm going to let the judge rule on this, and it's going to be set for January the 12th, today.
Yeah.
All right. Now, you would think at that point, the adjuster is sitting on a motion for default judgment. Before he can have his snack crackers, he would be sending that to a lawyer, right? And
You
saying,
would think, yeah.
answer this, call this guy, get this taken care of. Nothing. I was in a meeting yesterday at 4 o'clock with a new client. I signed the new client up. I came upstairs, set my stuff down, and I thought, okay, it's getting. I was planning on leaving around 5:30. I thought I'm gonna take care of any emails that came in while I was downstairs, put a few things together, and take them home. Sit down at my computer. At 4:30, I get an attorney filing an answer, because we do everything electronically. Filing an answer, filing a response to my motion for default judgment, and filing discovery questions on my client. At 4:30 on the night before court. I also get an email from said attorney, and the email says, I've been assigned the defense of this case. I'm attaching herewith an answer. I'm attaching a response to your motion for default judgment, and I'm also filing discovery requests that I want your client to answer. And having that, and my entry of appearance, okay, which is a pleading. And he says, and now having done this, I was wondering, and this is full circle, you ready for this? I was wondering, as a matter of professional courtesy, will you withdraw your motion for default judgment tomorrow? To which I replied, Dear blank, I will not withdraw my motion for default judgment, period. See you tomorrow. Hugs and kisses.
You put XOXO?
Yeah, I did. No. And so that's why I'm going to court today. The reason I share this, number one, is the purpose of the podcast is to give people a glimpse into the day in, day out here. And a lot of times it's fun and games and but a lot of times this shows you the gamesmanship that goes into cases. This shows you some of the stuff that we deal with and why sometimes the practice of law is incredibly frustrating. There's nothing complex about the situation that I just explained to you. There's nothing complex about that. This should have been a simple thing. You want to know what gets to me more than anything? What gets to me more than anything is I know this attorney got this file maybe on Monday morning of this week, or maybe Friday of last week. Even if he got it yesterday morning, no matter when he got it, the very first thing, if this attorney is going to ask me to withdraw my motion, is to pick up the phone, call me and say, hey, my name is so-and-so. I've been assigned this. Listen, here's what happened, and explain to me how the delay happened and where the wires got crossed and this, and then say, knowing that, are you willing to withdraw your motion? you know?
Right.
Or say, can you give me some time to get my answer filed and maybe delay your motion? Or, hey, you know, is there a way we can even work this case out, you know, that kind of thing. Nothing until the night before at 4:30, and then has the nerve to ask me as a matter of professional courtesy if I'll withdraw my motion.
Yeah.
This is where we're going to kick it over to the layperson, okay? I've tried to be as unbiased. I've given you my true feelings. That timeline is the timeline. Those are the facts. You're the lawyer in my chair. You're the one that's going to go over to court here, and as soon as the podcast is done recording, and you're going to see this guy for the first time, speak to him live for the first time. What would you do?
I mean, I don't think I would be standoffish with him or anything like that, but I definitely wouldn't feel like I've done him a disservice by not pulling back on the summary judgment. Now, here, real quick, this is the question. These are the questions that are rolling around in my head. So, who was procrastinating? Was it the insurance company? Was it the client not getting the insurance company the information? Was it probably a mixture of both?
Well,
did they not have representation up until this guy came along and was like, hey, this just got thrown in my lap?
I have some assumptions. I don't know. Let me preface this by saying there is no reason that there should have been wires crossed, because I informed the adjuster every step of the way what I was going to do.
Oh, yeah, you've done everything you possibly
the
could.
The second that adjuster saw that motion for default judgment, regardless of whether they had talked to their insured, the default judgment attached to it the complaint, it attached the timeline, it attached an affidavit saying everything I had done. At that moment on December the 15th, that file, regardless of whether they had talked, the insurance company had talked to their insured, who was the defendant driver, should have gone by FedEx, by email, but whatever, to an attorney. And that attorney immediately should react and say, oh my gosh, we've got a default judgment on one of our insureds, you know, one of our clients. Because the way this happens, and you've asked a good question, the attorney is in a very unique situation because he's being paid by the insurance company to afford a defense, but his client is the person, okay? So he has a very precarious situation to be in, I think, where they represent a person that's not paying their bill. You got me?
Right.
Now, indirectly, they're paying the bill because they've paid insurance premiums. The insurance company is giving the attorney marching orders because they're paying them. And the attorney represents the legal interests and to defend the driver. So the breakdown in communication could have been, I did serve the guy with the complaint, right? And he probably thought this, you know, it's no big deal. Let's go away. My insurance company will take care of it. I don't have to tell him, right?
Right.
So he doesn't tell him I got served. However, I told him he got served.
Yeah.
Right? And so did they not believe me?
So someone somewhere is not taking you seriously.
Right.
Despite you affording them every opportunity to start responding and making the right decision.
And you know what? I'm telling you, if this guy would have called me and explained whatever the breakdown was, I would have said, all right, get me an answer, get me everything, and if you get that over here to me, I'll withdraw my motion. Because I'm going to go over there today, and this judge is going to say, I'm denying your motion. Because the judge doesn't want to be in a position where he made the decision based upon a technicality. That's what's going to happen. What's getting me is that we're at this point, and I'm having to spend time, which is an attorney's, what we peddle, on something that could have totally been avoided. And then the main thing that gets me is that this guy tries to play this as a matter of professional courtesy.
Right. See, that's what I was getting ready to jump back in with. So I'm going to assume when this got thrown at him at the 11th hour, and considering what it is, would automatically know that this person is default, meaning that there's been a considerable amount of time for something to have been done before it got dropped on him.
Right, and he gets the file from the insurance company, so
that information will be there
in his lap.
Right. I would expect him to be professional, and if I get there and he acts crappy with me, I was censoring myself. If he acts in any way not in accordance with any sort of level of respect or courtesy himself, then that's when I would probably be like, look, how about common courtesy? A phone call would have been nice, not an email.
Right.
Because an email is no different than a text message. It's like that's why people say, "Oh, you got broke up with over text message, not a phone call."
I don't think.
Do you know who the attorney is?
I've never met him.
Okay.
Been practicing since 2000.
I didn't know if there was a level of expectation of what.
I sent a thing out on the listserv that I'm a member of. I asked attorneys if anybody knew him, and I'm
just Facebook stalk him. You'll find out.
Well,
you'll know right away. Once you see his cover photo, you'll get an idea of who this person is.
Nobody's responded yet about him. I know he graduated from the University of Kentucky School of Law in 2009. He's been practicing since 2009.
Do you think it's just a level of panic? I mean, regardless of what it is, it's a phone call at any level would have been better than an email.
And this is seeping over into something I wanted the conversation to go to. The practice of law has changed from the way I learned it and the way it's going. I never thought I would be that guy where I'm saying the younger lawyers, but let's face it, I'm 52. I have practiced law for 26 years, which means I've spent half of my life practicing law. I am seeing fewer and fewer attorneys who want to talk to you on the phone, who will pick up the phone and work through an issue. It's long 20-page emails, it's attaching documents to emails and saying, here, choke on this, here you go.
Yeah.
As opposed to the way I learned it. And the way I learned it is look, we're big boys, we're big girls, let's talk it out. And if we disagree, then that's why we've got the court over here to help us be the referee, and all while we're preparing our case to present it to a jury.
Yeah.
And the other thing that's happening in the practice of law is that there's just fewer and fewer jury trials. I am so excited. On the 24th, I'm starting a jury trial in Lexington because it's been 2 years since I've tried a lawsuit. Not because I don't want to, just because nobody's doing it anymore. They're just not doing it. And that's not the way I learned. I learned by preparing almost every case for trial, and they didn't resolve until right before trial, if they resolved, or then if not, you went and let the jury tell you who was right or wrong.
Yeah.
And I'm seeing this, we've talked about mediation being one of the big reasons for that. But anyway, it's something that I've wanted to talk about on the podcast a few times. This gave me the perfect way to talk about just some of the professional courtesies in the profession. And I hope that our listeners, get a little glimpse of something that they've not had or understand better, some of the day in, day out stuff.
I've noticed that shift in social cues and things. It's in terms of like, I've met so many more people that say, I would rather, text me, don't call me. I don't want a phone call. I want a text message. And I'm thinking,
there's so much lost in text. You can't get
They're cold.
eye contact, nothing.
You don't get any inflection. You have to infer all that yourself. So and then things get lost in translation, and that's why I've had so many issues over the years with. I would say the most amount of confrontations I've had with people is because they misunderstood something that was trying to be gotten across in an email or a text message. And then as soon as it becomes this back and forth, I'm like, let's just get on the phone. We get on the phone and it's resolved in seconds.
Right.
Because you can hear that person's, the true meaning behind what they're trying to say.
I'm currently reading a really interesting book, and it's called Shallows, How the Internet is Ruining Our Life. Okay? It's called Shallows. It's about internet addiction. Not just pornography or things, like just the whole idea of how you get binged with this, dinged with that, pinged with this, and how we're tracked and how it just takes over our life. And one of the things that when you were talking about the tone of text and email and the misinterpretation of it, the guy gives a wonderful example. I'll share it. So PJ is not feeling well, and PJ decides to send Travis a text about not being at work. Okay. Or let's check. I think the actual illustration that he uses in the book is that you're going to be late because your child doesn't feel good and you want to get a doctor to look at him. Okay.
Yeah.
So you send me an email. I'm your employer. I'm the person that you have to report to, okay? And you say, hey, Travis, you send me a text, because it's the quickest, easiest thing to do. Hey, Travis, Connor doesn't feel well this morning, kind of concerned because he has a fever. I'm going to take him to the doctor, so I'll be probably an hour or two late getting into the office, all right?
Okay.
And so the author says, what's interesting there is I reply, okay. In seeing you and sitting here, and I go, okay, you can tell. You can he doesn't care. That's fine. But when you get a text and all it says is okay, immediately your mind is, oh, gosh, that was short. What does he mean by okay? Is he put off by the fact that I've asked about this?
Yeah.
And then he says, oh, mate, maybe he was just busy. I know that in the mornings he works out or whatever. And then, usually he does say more than that when he's being nice by text. Like he'll say, yeah, hope he's okay. No worries, that kind of thing. We care about you. Well, let us know. He's like, he didn't say that. So he's mad. And so you come into work with a defensive attitude thinking, well, Travis is mad at me, and you're like on pins and needles waiting for me to come down there and say, PJ, when all along I meant okay. And so what a perfect example of the way the internet or the way we communicate is ruining our lives.
Yeah.
Because we don't know how to read into okay, right? We don't know how to read into that. So it's an interesting thing. And when you start examining yourself, you're like, man, it does affect me that way.
Right. And it's funny. And here's an example, I think, too, is like right now I'm writing a script.
Right.
Okay.
New Year's Eve.
Okay. Yeah, New Fear's Eve.
I'm sorry.
It's this new script. Any script. When you're writing a script, you know that at some point someone is going to read it. And because of that, there are times when certain lines of dialogue that you are writing need to be have a certain inflection or perceived a very specific way. And like you said, if the character says, okay, the reader can interpret that any way they want. They can put any emotion. Right. And sometimes there's a very specific emotion that needs to be conveyed. So there's these things called parentheticals that you put directly after the name of who's saying it, and it'll say yelling or very angry. So you're telling so you're telling the reader, okay, when you say this line in your head as you're reading, this is how you need to be saying it.
Or when I wrote it, what I'm imagining is the way you're going to say it.
The emotion, because a script is not the same as like a novel to where you get all this information and then the dialogue happens, so you can really kind of put things together more in your head. So you have to tell the reader through these parentheticals that this is the emotion that needs to be conveyed in this dialogue. And it's funny because that's 100% right, because I've done that same exact thing that you were just saying. Because when you read something okay or all right, it's like, are they saying all right? Or are they saying all right? Or
what's funny is the little emoticon with the thumbs up is actually,
I hate that.
It's even more abrasive. It's like, gotcha, and I use them sometimes. Reading this book has helped me. Number one, I'm trying to make a commitment on the weekends to basically shut my phone off. Just maybe pick it up once or twice a day to make sure nothing emergency is going on. You know what I'm saying? Because we were designed to be people who
be social.
It's right, and to be together and social, and then also to have quiet, just to let our brains rest.
Right.
So anyway, before we conclude, there's a couple of things I want to touch on. A little bit of bad news out of Owensboro, but a little good news for you and I. Was at the doctor's office at one of the urgent cares here in town on Sunday. I was sitting there with Missy and Jackson. This guy, his name's Dave, don't know him from a man in the moon, comes, and I noticed him through a hallway and over in a more common area. He was an employee there, I think a nurse or a nurse practitioner or something. Mm-hmm. And I was speaking to my friend Randy Sidehamel. I was sitting there talking to him, And this guy comes walking through after Randy left, and this guy comes walking through, and he says, "Hey," he goes, "I just wanted to introduce myself." He says, "I'm David." And he didn't say his last name. He goes, "I heard your voice through there." And he said, "I asked somebody, is that Travis Holtry?" And they said, "Yeah, he's in there with his wife and his son." He was like, "I recognized your voice because," he goes, "I listen every week to your podcast."
That's awesome.
Oh, I was like, well, that wasn't going the way I thought it was going to go, because most people say, "I recognize your voice from the radio." And
yeah.
he says, "No," he goes, "I don't listen to the radio." He said, I don't, even in my car, I listen to podcasts.
I only listen to text messages.
Right. And I listen. And he said, "I love your podcast. He goes, "I've listened to every episode.
Oh, wow.
Yeah." And he was like, "I really enjoy listening to you and PJ." And he's like, and I was like, "Man," I was like, you're the fan of the year." I said, "You may be the only fan." I was like, but anyway, I wanted to give a shout out to this guy. And when he's listening to Dave for listening and being faithful, we hope that you continue to enjoy the content. And this will also be a free plug for the Springs Urgent Care and the folks over there. If you need COVID testing or are ill or have a minor emergency, those folks are really good. They listen to great podcasts.
That's awesome. You should reach out. Maybe we'll have you on the podcast.
That's right. Yeah.
We could do that. We can have random guests,
people that
anybody.
like our podcast.
Yeah, we should do that.
Last thing I want to say is just a little bit of a thing. Our community means a lot to us, and in all the different communities where we have offices, we tend to want to be involved to make our communities better. And we just want to talk, I just want to point out that it's bothersome when here we are, it's today's the 12th of January, and already in our city, in Owensboro, it's not great news in Chicago or New York, but these are the kind of headlines you see there. You know what I'm saying?
We're just not used to this sort of thing where we're at.
And we shouldn't be, because it's a bad thing.
Absolutely.
But already in Owensboro, we've had 3 shootings in 2022. In 12 days, we've had 3 shootings. So that's averaging 1 every 4 days. And serious shootings where also property is hit, individuals are hit, by gunfire. There is a lot that leads to that. I think that and we're not going to get into it, COVID has just totally flipped things upside down. Behavioral health that's not being treated and acknowledged, family environments, and just passions and things that just get involved. And I just want to encourage our listeners to pray for our community, and to also to look for opportunities to help in any way they can. And let's not just start accepting this as a part of the day in, day out. What can we do to effectuate change? What can we do to make a difference? And I would think a lot of it begins with listening and being and just being aware. And if you get the chance to intercept or to be a part of some person's life that you think can make a difference, make the difference. Do it. And
absolutely.
Just because we're passionate about our community and don't like to see headlines like that. And they're concentrated in one area of town. Obviously, we looked at that before the podcast began. And so if we can make a difference, if you know someone that can make a difference, just don't shrink back from your responsibility to help people. Anything else you want to add? It's a great podcast, great content.
No, I think we've pretty much covered everything.
Hit everything. And look forward to next week.
Yep.
This will be dropping here on Friday. And then we will continue to think about our content for the podcast and guests for the podcast for 2022. We're off to a good start.
Mm-hmm.
Until next time, this has been Done Lite, brought to you by Foreman Watson Holtry. We would encourage you to find out a lot more about the law firm on the firm's website, which is fwhlegal.com. We're also on Instagram, YouTube, Facebook.
Grindr?
No.
I'm kidding.
Until next time, thank you and for listening, and if we can ever help you, let us know.
This case should never have come to trial.
I don't think it's fair to call my clients frauds. Because one time I turned into a dog and they helped me. Thank you.
Your Honor, we would like to withdraw our plea of not guilty and enter a plea of guilty.
This trial is a travesty. It's a travesty of a mockery of a sham, of a mockery of a travesty of two mockeries of a sham.
If we are to have faith and justice, we need only to believe in ourselves.
And the truth shall set you free!
How do you plead, guilty or not guilty?
Oh, guilty, but with a real good excuse.
I think the truth will come forth.
You can't handle the truth!